Welcome, and thank you for viewing this Office of Family Advocate Child Fatality webcast. My name is Stacie Bladen, and I'm the Director of the Office of Family Advocate.
And my name is Seth Persky, and I'm the Family Advocate Specialist. The Office of Family Advocate, or OFA, is a unit within DHS Central Office, and one of its responsibilities is to monitor, track, and review fatalities of children who are state or court wards. These involve children who, regardless of placement setting or cause of death, died while under court jurisdiction and DHS care and supervision.
On average, there are about 20 abuse-neglect ward fatalities per year in Michigan. After peaking in 2008, there has been a steady decline in the number of ward fatalities to a low of 14 in 2011. Only 7 of the 124 ward fatalities that occurred over the past 6 years were the result of abuse and neglect by the temporary caregiver. The majority were ruled natural deaths, followed by accidents.
We have found that retrospective case reviews, such as those done when a child dies in care, provide valuable insights to inform future practice and enable continuous quality assurance activities. This short webcast presents relevant facts pertaining to the life and death of a single child who died while under supervision of DHS in the court. The presentation will emphasize pertinent policy requirements and offer practice tips and resources that we hope will be beneficial to you.
The fatality that I'm going to highlight today involved an 11-month-old child who died as a result of extreme prematurity and medical complications. We're going to start by talking about the child's history. Dee was a twin born at 26 weeks gestation. Due to extreme prematurity, he had multiple medical complications: hyperbilirubinemia, respiratory distress syndrome, sepsis, anemia, apnea, pulmonary immaturity, intraventricular hemorrhage, and osteoenia. After birth, Dee was intubated, had a nasogastric tube, and was treated with a nasal CPAP for 39 days. Dee stayed in the hospital for 11 weeks before being discharged home to his mother and 6 siblings. This next section will highlight the CPS intervention with the family. Within a month of discharge, CPS investigated and substantiated neglect by Dee's mother because she was not meeting his medical needs. During the open Category 2 case, Dee was rushed to the hospital after becoming unresponsive. He required CPR and remained in the pediatric intensive care unit for 2 weeks. He was discharged back to his mother and required oxygen, deep suctioning, and an apnea monitor. Referrals were made for a parent aid, Healthy Baby Healthy Start, early on, and the Family's First program. Cribs were provided because Dee and his twin had been sleeping in their car seats. A visiting nurse notified CPS that Dee's mother was not following through with recommended medical care, including not administering prescribed medication. CPS responded to the home and found Dee in his car seat with no adult supervision. CPS filed a petition and the court ordered removal of Dee from his mother. This next section highlights the child's placement. Prior to placement, Dee was evaluated at the hospital. Dee was placed with his maternal aunt, who had a close relationship with Dee's mother and was aware of his medical needs. On the day of placement, CPS completed a relative safety screen, which noted household members included Dee's aunt and Dee's 13-year-old cousin. No household members had felony convictions, and Dee's aunt had several unconfirmed CPS complaints in which she was the alleged perpetrator. Although documented in the aunt's CPS file, the safety screen did not include the fact that Dee's aunt had been a confirmed perpetrator of child neglect 4 years prior in another state. 2 weeks after placement, DHS contracted with a private agency to complete the DHS 197, the Relative Caregiver Home Study, and initiate the licensing process. The home study completed by the foster care agency indicated Dee's aunt had 3 prior unsubstantiated CPS complaints. Dee's aunt denied mental health, substance abuse, or domestic violence history, and that a crib was set up for Dee. Again, although documented in the aunt CPS file, the relative home study did not consider the fact that Dee's aunt had resided in a domestic violence shelter or that she reported suicidal ideations just 2 years prior. Next, I'd like to present the services for the child in placement. Dee no longer required oxygen at the time of placement. 2 weeks after placement, Dee participated in a physical therapy evaluation. He had PT twice a week for 45 minutes to improve mobility and strength. 2.5 weeks after placement, Dee had a complete physical exam, including a neurodevelopmental assessment. Dee was taken off aminophylline but continued on albuterol and Pepsid and was required to use an apnea monitor for another 2 weeks. Nursing services visited Dee in placement every week. D was referred for a helmet fitting to address severe plagiocephaly, or flat head syndrome. 9 weeks after placement, someone called CPS and reported that there were infants in the aunt's home who were crying for hours. The complaint was not confirmed. The foster care worker saw D at least monthly, including in the placement setting. Physical therapy was scaled back to once per month. D no longer required a helmet. He was crawling and pulling himself up. Next, I'd like to highlight the fatality facts. After 5 months in placement, at age 11 months, D was found unresponsive in his aunt's home. D's 13-year-old cousin picked D up around 11 a.m. and found him limp. CPR was attempted, 911 was called, and D was pronounced dead at the hospital. D's aunt said that D was napping on the couch and had an ear infection. He had just completed a 10-day course of antibiotics. D's last nebulizer treatment was the night prior. D was active and there were no concerns with his medical status or progress. D's aunt told CPS that for the last several days, D had been sleeping on one couch while she slept on the other, even though there were beds. CPS assigned a Category 4 disposition. Law enforcement investigation found no charges. The autopsy found no signs of trauma or neglect, and the death was ruled natural due to medical complications. I'd like to highlight 3 practice points. 1. Thorough and timely completion of the DHS 197 Relative Caregiver Home Study. 2. Reinforcement of safe sleep. 3. Assurance of medical care. Regarding the first practice point, thorough and timely completion of Relative Caregiver Home Study, this policy can be found in FOM 722-3. After the initial relative safety screen is completed, a DHS 197 Relative Caregiver Home Study must be completed within 30 calendar days of the child's placement in the relative's home. Among other things, completion of the 197 must include face-to-face contact with each household member, address any prior CPS substantiation, including out of state, describe and evaluate any history or prior issues related to mental health. The foster care agency is responsible for ensuring that placement selection meets the criteria outlined in 722-3. A foster care agency cannot be expected to accurately assess the safety and appropriateness of an unlicensed placement without first considering all available pertinent information. The Child Protection Law allows CPS to share pertinent CPS case file information with a private child placing agency responsible for the child's health or welfare. If the private agency suspects that they don't have all the information necessary to evaluate the placement, they should contact CPS and request the information. The next practice point is reinforcement of safe sleep. At each monthly foster home visit, the foster care worker must discuss safe sleep guidelines with the child's caregiver when children under 12 months are placed. Observe the child's bedroom, including caregiver compliance with safe sleep guidelines. Include babysitters, other relatives, daycare providers, older siblings, and anyone else who is left to supervise the child in discussions around safe sleep. DHS Forms 904 and 904A are quick reference tools that caseworkers can use for monthly visits. Let's take a quick look at the 904A, which is the caseworker child visit tool. You'll see that item 9 prompts an assessment of safe sleep practices when infants are placed. Item 18 prompts the worker to identify the child's medical needs and appointments. Items 22 and 23 require the worker to document the child's medical appointments, treatment, and medication. And at the bottom of the form, the worker can identify follow-up activities, such as need to speak with the child's doctor, therapist, or other professional involved in the child's care. The final practice point 3 is assurance of medical care. This policy can be found in FOM 722-6. The foster care worker must make at least monthly contact with each professional involved in the child's care to solicit the professional's observations and opinions regarding the child and caregiver. All reports from professionals must be summarized in the USP, with the original report filed in the case record. Each visit with the caregiver should address the child's medical concerns, appointments, treatment, follow-up care, and therapy updates. Do not rely solely on the caregiver to keep track of medical appointments, diagnosis, medications, and status. It's the worker's responsibility to obtain that information and speak directly to the professionals involved in the child's care. Use the Michigan Medical Resource System, or MRS, if you have questions about the child's diagnosis, medical care, or treatment recommendations, or require second opinions. MRS provides medical consultation statewide to workers or medical professionals. The MRS will review cases and can assist workers in understanding a child's diagnosis and medical needs. The medical passport forms must also be completed, and they must document the child's health status and medical needs at the onset of placement, all initial medical screenings and assessments, all information regarding follow-up appointments, all prescriptions including drug name, dosage information, diagnosis, and physician name. Finally, I'd like to highlight some resources that might be useful to workers in the field. Funeral payments and restrictions can be found in FOM 903-10. For TCWs, the child's family is responsible for handling arrangements and making payment. For MCIs, DHS is legally responsible to make funeral arrangements, and payment for expenses may be made through the state, ward board, and care account. Safe sleep information can be found on the DHS public website at www.michigan.gov/DHS and click on the Safe Sleep logo. The Medical Response System, or MRS, can be contacted at 877-391-2345. Grief support for families can be found at Tomorrow's Child at 800-331-7437. Employee Traumatic Incident Support can be contacted at Employee Service Program at michigan.gov/ESP or 800-521-1377. And finally, fulfilling death alert notification requirements can be found in SRM 172 or by contacting DHS Office of Family Advocate at 517-335-3475. Thank you for taking the time out of your busy schedule to view this webcast and for your efforts to strengthen practice in the field.